mediation and arbitration mechanisms. The jurisprudence in this area has developed immensely in the recent years, making it a timely and relevant topic for discussion. As many of you are aware, technical standards and intellectual property increasingly are interlinked in today's economy, and resolving such disputes efficiently, especially those that are cross-border or highly complex, is more important today than ever. With that context, this webinar will explore how ADR mechanisms offer effective and flexible solutions to the parties involved in FRAND-related negotiations and conflicts. Today's discussions will provide valuable insights into structuring ADR processes that are both strategic and sustainable. We are honored to have a distinguished lineup of speakers who will be sharing their experiential learnings and perspectives throughout the session. Before we begin our technical discussions, it is my privilege to introduce Mr. Arun Chawla, Director General, Indian Council of Arbitration and former Director General, FICCI. Spanning more than 38 years, Mr. Chawla's professional journey reflects deep engagement and leadership across the legal, corporate, and policy sectors. Mr. Chawla has led high-impact global collaborations, organized prestigious conferences in the UK, UAE, Australia, and Bhutan, and modernized ICA's infrastructure to global standards. He played a key role in the high-level committee on making India a hub of arbitration and actively promotes gender diversity through a dedicated forum for women arbitrators at ICA. A prolific speaker and author, Mr. Chawla has served on multiple national committees and continues to influence policy reforms and institutional excellence in ADR. May I now invite Mr. Arun Chawla to take the virtual floor and address the audience with his opening remarks. Over to you.
Thank you, Ruchita. Once again, good afternoon to all friends joining from India, and good morning to everyone joining from WIPO, from Geneva. Honestly, I feel privileged in opening the discussion on the subject of rising importance at the intersection of law, innovation, and global commerce, and that is mediation and arbitration for standard essential patents and disputes pertaining to fair, reasonable, and non-discriminatory, which is called FRAND in the chronic form. Ladies and gentlemen, this is not merely a legal discussion. It's a conversation that goes to the heart of how we manage and resolve commercial conflict in the digital age. Mediation and arbitration are not just alternate dispute mechanisms. They're necessary strategic instruments for resolution of disputes. Let me briefly revisit the context. A standard essential patent protects technology that is indispensable for implementing an established industry standard, be it Wi-Fi, USB ports, or 4G VoLTE. These technologies support the seamless functioning of devices used by billions of people worldwide. India has emerged as a key jurisdiction in SEP litigation. The 2024 decision in Ericsson versus Lava by the Delhi High Court, awarding around $30 million in damages, was one of the most significant in Indian SEP history. The court emphasized the need for fair, non-discriminatory licensing, balancing the rights of innovators and those of implementers. Similarly, in 2025 judgment in favor of Philips involving expired SEPs on DVD technology shows how India is fast becoming an anchor jurisdiction in these increasingly complex disputes. Ladies and gentlemen, litigation is full of unforeseen risks. As these cases demonstrate, it can impose sensitive business information, damage commercial goodwill, and impact investor sentiment. That is where ADR, and in particular mediation and arbitration, offer transformative value. ADR brings with it a host of advantages, the most important being confidentiality to safeguard proprietary business data. Secondly, speed and cost efficiency, critical in time-sensitive industries. And lastly, and crucially, international enforceability through mechanisms like the New York Convention. In today's globally networked and reputation-sensitive environment, ADR is not a soft option. It is a commercially intelligent choice. Mediation in particular has shown immense potential in SEP cases. Unlike courts, which provide limited remedial frameworks, mediation enables tailor-made outcomes, licensing arrangements, cross-licensing, or commercial settlements shaped by mutual interests. And this is not just about multinationals. For India's small and medium enterprises who are at the front line of digital innovation, ADR is affordable, efficient, and empowering. Speed, discretion, flexibility, and continuity constitutes the value proposition of ADR. Dr. APJ Abdul Kalam, former President of India, once said, "Peace and prosperity must go hand in hand. Where conflict is inevitable, let wisdom guide resolution." This ethos underpins mediation and arbitration, not as compromises, but as tools of wise resolution in a commercially interconnected world. Let us also recall the words of Dr. B.R. Ambedkar, the principal architect of Indian Constitution. Quote, "If you want to maintain democracy, not merely in form, but also in fact, the first thing you must do is to hold fast to constitutional methods of achieving your social and economic objectives." Unquote. So, ladies and gentlemen, in the context of dispute resolution, arbitration and mediation represent exactly that: constitutional, lawful, and effective methods to uphold justice without undermining economic momentum. In closing, I look forward to today's engaging discussions led by an accomplished panel of Indian and international experts. Together, I hope we will explore the practical solutions, share global experiences, and reaffirm the vital role of ADR in protecting innovation, enabling business, and sustaining growth. Thank you very much.
Thank you, Mr. Chawla. Your impactful remarks have set the perfect tone for today's observations. Thank you once again. It's now time to delve into the technical sessions, but before we do so, I would like the audience to note that the question and answer round will take place towards the end. You may either post your questions in the Q&A box or raise your hand, and we would be happy to address them as the time permits. The first session for today is Navigating SEP FRAND Licensing and Disputes in India, which will be led by Mr. Nishant Sharma, Lead Counsel, Patent Licensing and Litigation, Dolby Labs, India, and Ms. Archana Shanker, Senior Partner, Anand and Anand. It's a pleasure to welcome Mr. Sharma and Ms. Shanker for sharing their observations on the topic. Our first speaker for the topic is Mr. Nishant Sharma, who leads Dolby's patent licensing program in India and Southeast Asia and oversees its litigation strategy against unwilling licensees in India. With deep expertise in SEP licensing, patent pools, and standard-setting organizations, he is skilled in target identification, bilateral negotiations, and strategic enforcement. He plays an active role in IP policy advocacy, contributing regularly to national discussions to shape evolving IP frameworks. Passionate about global SEP developments, Mr. Sharma collaborates with external counsel on effective litigation strategies. He is also associated with leading Indian law schools, contributing to IP education and mentoring future stakeholders in the field. Mr. Sharma, the virtual floor is yours.
Thank you, Ruchita. A very good afternoon to all the participants and the attendees. Uh, Thanks to FICCI and WIPO for inviting me for this talk. Uh, a very brief introduction, though Ruchita has already said a lot. I'll just say I handle the patent licensing and litigation for Dolby in India and Southeast Asia. So what I plan to do today is bring some perspective into how licensing happens and how some disputes reach a stage where we need to litigate, and how ADRs could provide an alternate path for some of these disputes. Maybe we have, and I'll try to share some experiences on that. Though I would say ADRs, as of now, have not been so popular. And again, I believe my colleagues at WIPO may not agree with that, but as of now, I'm just talking in terms of what I have observed, and maybe my experience might be limited in that respect. But yeah, obviously, I came here to be enlightened by WIPO as to how effective ADRs have been. But having said that, I can confirm that we have used ADRs in some specific scenarios, and today I'll discuss some of those where we have been using ADRs. So I'll just share my screen. Just hold on. Okay, I think I am not able to share my screen. Maybe what I'll do is I'll just talk from my slides, so you won't see anything. But I can share my experience on how we have been using how we have been licensing. So I would just begin by saying that we have a well-established patent licensing business. Have been doing it for quite some time. Apart from what we do on the proprietary licensing, which and most of you might have heard of Dolby's proprietary technologies such as Dolby Atmos, Dolby Vision, which are being implemented in many devices, audio visual capable devices. We also contribute in another aspect of technology, which is standard essential patents or developing standards. So our patents have been incorporated in standards, and this makes us one of the prominent SEP licensors in some of the most advanced audio visual technologies, and some of these are advanced audio codec, which is also known as AAC, another a very successful audio codec, which has been, and the program on licensing has been running for many years now. There are other standardized technologies such as HEVC, which is a video compression codec. A predecessor to that was AVC. Dolby also has patents on that. Then there are some newer programs or standards such as AV1, VP9. All these are video programs, video standards. Then there are voice codecs, newer voice codecs such as Opus, EVS, all such standardized technologies, specifically on the audiovisual side. We have recently started contributing towards the standards on wireless power as well. And that is on account of Dolby acquiring GE licensing, which contributes a lot in video on wireless power standards. So this is very brief about the various standardized technologies where we contribute our patents, which are the standard essential patents. The access to Dolby's global SAP portfolio is available at the option of licensee through a bilateral program or a pool program. So you can either take a bilateral license, which is you negotiate the license with Dolby as one of the licensors, or you go to a pool. So now what a pool is like a one-stop shop wherein you have several licensors on one particular standardized technology. So maybe there is an AAC pool. The AAC pool, a very popular pool on AAC or the Advanced Audio Codec is the VIA AAC pool. So if you go through the website of VIA, you'll get to see that there are a number of licensors who have contributed their patents to the standard, the AAC standard, and they have all come together, forming a pool and offering a pool license on all that entire portfolio to whosoever is willing to take a license on AAC. So that is a very efficient way of licensing, because you have a one-stop shop wherein you go and take a license on one particular codec from covering all the licensors. So you need not go to each and every licensor having SEPs on that particular standardized technology and spend time on negotiation and spend cost on negotiation. By the way, negotiating a license is a very costly affair in the sense that you need to spend time, you need to provide details. There are discussions that happen on the technical aspects, on the legal aspects, and also on the rate. Mr. Chawla mentioned about the FRAND rates, which is generally the point of contention amongst the licensors and licensees whenever these discussions happen. So, so this is another approach, an effective approach. You approach a pool and take a pool license, saving time and cost. Generally, in all these discussions, even for a bilateral license or a pool license, the guidelines that are followed are the Huawei ZTE guidelines, and you can search on the internet about, in case you are not aware of, already aware of Huawei ZTE guidelines. These, there was a seminal judgment from the Court of Justice of the European Union, which had set the guidelines for how, what is the ideal behavior for a licensor and a licensee in any FRAND discussion. And in all these discussions, or for a license that happen either bilaterally or through a pool, the Huawei ZTE guidelines are followed to the core, because the main aspect of any licensing negotiation is that all information, the necessary information, should be made available to the licensee so that he or she it can take a well-informed decision before taking a license. Again, coming to the benefits of pool licensing, there is a collection of licensors. You don't have to go to different licensors, as I already said. The other benefits are sometimes pools also have an provide a sort of validity and essentiality analysis, the essentiality analysis primarily of all the patents that have been included in its pool. So before any standard essential patents or a portfolio is included in a pool for licensing, the pools would evaluate whether those patents are actually essential or not. So there are third parties who are commissioned to check the essentiality of the patents that have been submitted for inclusion into the pool. And before the patents are included, the essentiality is evaluated, it is certified, and only then the pools would include the patents. So any licensee who's approaching a pool gets a sort of confidence that whatever patents they are taking for license, they are getting in a license, are deemed to be essential on account of the essentiality test. then there is a huge base of licensees. So it also points towards the frankness of the rate. So of the royalty rate that is being offered, because so many licensees have already accepted that rate, it becomes the market practice. There is a wide market acceptance of the FRAND rate that is being offered to a particular licensee. There are several other people who are already paying that license rate, which means that there is a huge relief to the licensee, that they need not doubt the frankness of those rates. Again, validity, since a large number of licensees, and most of these licensees are highly technical companies who have taken a license from the pool already. So they would have already evaluated the validity of the patents. So if there is a huge number of licensees who have taken a license, there is a high probability that most of the patents, or the patents that are being offered for license, have a validity attached to it. So in a way, these are all confidence building measures that are available when you go for a pool license. And these are a few benefits of going for a pool licensing as opposed to a bilateral license. Again, the pools also help solve the problem of, and I would say these are perceived problems in a licensing field, which is royalty stacking or transparency concerns. So royalty stacking is, I would say, a very hypothetical concept wherein people have argued, and licensees generally argue, that there is a fear of royalty stacking if you go to each of the licensors and they keep on adding their royalty fee for a particular standardized technology, then the royalty stack keeps on growing, and the overall royalty that a licensee has to bear for a particular standardized technology may be very high. So though there is no, I would say, empirical evidence of royalty stacking happening in the market, but still a pool licensing aspect helps in meeting these concerns about royalty stacking. You have one rate that is being provided for the entire pool of patents. So there's no royalty stacking concern as such. Transparency concerns, people say that they don't get to know who are the other licensees who have taken a license, what are the patents that are being offered for license. So pools would generally publish their rates. They would publish the portfolio, or at least they'll provide the portfolio that is on offer. And also a draft PLA is also available at some point of time from pools. Sometimes pools also publish it on their website. So in that sense, pools address the situation or the problem of transparency, which many licensees raise often. Again, there are other benefits as well. Sometimes pools also offer differentiated rate structure, wherein maybe for a developing country they would have a specific rate structure, and for a developed economy they would have a separate rate structure. So if you are selling devices in a developing economy, you will be paying slightly lesser discounted rates as compared to what you would be paying if you are selling in a developed economy. So these are some of the benefits of pool licensing. Again, bilateral licensing is something where you are negotiating with the party one-on-one, with the licensor one-on-one, and which means that if you want comprehensive coverage, you need to go for licensing discussions with each and every licensor, depending on the jurisdictional aspects and your coverage, the type of coverage you want. This also gives you a sort of independence in choosing which licensor you want to approach, because suppose you may not be, you are only selling in India, and the standardized technology has licensors, and some of those licensors do not have any patents in India. So if you have plans of only selling in India, you may not want a license from a licensor who doesn't have a patent in India. So in that case, you can, in a way, select only few licensors and approach the other ones only when you think of venturing into the markets where they have patents. So this is the type of flexibility you have in case of a bilateral licensing. Again, it all depends on the risk profile. It also depends on the type of business projection a particular licensee has in respect of their business and the jurisdictions they plan to enter. Having said that, a bilateral licensing always has a risk of litigation, because if you take some licenses from some specific licensors and leave out the other ones, obviously they may come after you in case they have patents and you have not taken a license to their patents or standard essential patents. So this is a brief sort of I would say distinction between the type of licensing scenarios that are prevalent in the market. How a typical licensing engagement works, I would say I can talk about myself. We identify potential licensee, check what are the target devices, what are the devices that may be using these standardized technology, evaluate those devices in the sense that how those devices are implementing the standard. So the devices may have to be tested. You may have to do some deep dive into those devices to check how they are implementing the standard and how your patents are being implemented. Then you send an infringement notice, obviously complying with the Huawei ZT guidelines at the side. You provide all the details of your the portfolio, the rates, and the draft PLA that is includes all the terms and conditions for the license that is being offered. Then there is an exchange of offers, counter offers from both the sides. And my observation is generally in all these discussions, the primary concern is the rate, the FRAND rate. Though both the sides do talk about the technical aspects, but usually it is the rate where there is a requirement of meeting of minds of both the sides. Otherwise, most of the issues are still solvable. And then the negotiations also involve the discussion on the aspects, on the terms and conditions of the license. Maybe, as I said, royalty rate. Then what is the term of license? Some license or licensees may say that based on their business projection, they are looking only at a 3-year license, which may be renewed after 3 years, or just to be on the safe side, they take a 5-year license, and there are different examples of how the terms that licensees take. There's a discussion on the licensed product. What is a product that is being covered under the license? So obviously the licensee would want all their products to be covered, but again, they have to pay a royalty on that. So they have to find out a reasonable mix and evaluate internally as to what are the licensed products that would be implementing the standardized technology. And then there are different clauses such as the audit clauses, termination clauses, and things like that. So coming to how ADRs can be used in licensing negotiations, I would say, again, ADR is more of when there has to be a meeting of minds of both the sides that they should be agreeable to ADRs. And specifically, I would talk about arbitration, which we have used in some of our engagements. It has to be, you cannot decide critical issues like validity, essentiality, and even maybe at times infringement based on arbitration. I would say where arbitration could play a big role is where both the sides are mostly aligned on all other aspects, and the major point of contention is the FRAND rate that is applicable to the licensee. It is where the ADRs could be implemented, and again, it is subject to both the sides. Both the sides have to agree to come to a discussion table, get this resolved through an arbitration instead of going to litigation. Why not litigation? Because litigation, as Mr. Chawla said, it is costly, it is time consuming. Also, I would say, and one point that I can like drop in from the practical industry aspect is you also spoil your relationship with the licensee when you enter into litigation. So since the licensee is in the field, in the technical field, I would be providing my license on some other technologies also to the same licensee. I do not want to spoil that relationship ideally with the licensee. So litigation is a bit acrimonious at times, at least in India. That's what I've seen. So I would say arbitration, in that sense, provides a very amicable solution. In case both the sides, again, as I said, I'll emphasize again and again on that, both the sides have to agree to that they want a particular issue and specifically the rates to be decided by an arbitration panel. Between mediation and arbitration, I would always say I believe arbitration is more has a greater legal sanctity as compared to mediations. It's more formal procedure. You get an award which you can enforce. So I would always say that from the perspective of SEP holders, arbitration would make more sense as compared to mediation. But yeah, obviously, if there is an avenue wherein you can explore mediation, that's good as well. I believe Archana ma'am would be talking about mediation from the perspective of the Commercial Courts Act. So I leave this topic for her. Maybe some of the challenges that I believe exist in adopting arbitration would be how an arbitration panel can help in deciding FRAND rates. Would they have an economic understanding of the situation of both the licensor and the licensee, and also the comparable licensees of the licensor, so as to derive a FRAND rate that can be made applicable to the particular licensee? So that is a challenge, I believe, that needs to be addressed, which may, and once we overcome this particular hurdle, I believe there will be many takers for arbitration, provided the other side is agreeable to that. And finally, maybe at what stage I would like to take up arbitration again. You go through the initial phase of discussion, and finally during the discussions or after the discussions, you realize that okay, the rates is the rate is where the problem exists as of now between the two sides, and we are agreeing on most of the aspects. So let's decide and go for arbitration instead of litigating. So and whenever you are having these discussions, both the sides enter with a view that they need to take a license or enter into a licensing engagement. But eventually, when the discussion proceeds, both sides know that maybe it might be going towards litigation. So probably this is where both sides would have to come together and again try and find a resolution, an amicable resolution through arbitration. This is what I would say is desirable. Yeah, so I think with this, I'll hand it over to Archana ma'am to give us the perspective on the litigation aspects of licensing.
Thank you, Mr. Sharma, for those insights and thoughtful reflections. Our second speaker is Ms. Archana Shanker, Senior Partner, Anand and Anand. She is a zealous patent practitioner setting new patent narratives in India IP jurisprudence while heading the Patents and Designs Department at Anand and Anand. With over 35 years of experience across sectors, including pharmaceuticals, life sciences, ICT, and biodiversity. She is the first woman president of FICCI India and an advisory board member of IAM's Women in Patents event. Featured among managing IP's top 250 women in IP for 8 consecutive years, Ms. Shanker is known for her unmatched legal and scientific expertise. A strong advocate for women in IP, she leads a multidisciplinary team handling enforcement, oppositions, revocations, and plant variety protection matters globally. Over to you, Ms. Shanker.
Thank you, Ruchita. And thank you, WIPO and FICCI for organizing this, Mr. Chawla. I think it's extremely a privilege for me to be in the second round of series of, mediation and arbitration. Just give me a second round. Nishant has kind of already set the background for this session, and probably, what I plan to do in this 15 minutes that I have is to deal with some inbuilt ADR mechanisms that we have in India, and essentially as to how we would differentiate between adopting an arbitration process between an SAP domain versus other technical domains, as in life sciences. We all know that when we do talk about SAP, usually SAP patent holders, the patent holders are under a special voluntary commitment on part of the patentee to license SAP on FRAND terms, whereas such kind of arrangement obviously does not exist in all other kind of domains, particularly in pharmaceuticals or life sciences. So probably when we do talk about mediation and arbitration, or generally we do talk about ADRs, we might just have to kind of make that distinction between the nature of technical domains that we're dealing with, and SCP being a special, what we could call a special category vehicle, has to be dealt with very separately, as opposed to domains like mechanical, life sciences, non-chemical, things of that kind. I do have a short presentation just to kind of give structure to this session, to my session, and let me know if everybody can see that. Everybody can see that presentation.
Yes.
So just before I kind of dwell into the issue of ADR mechanisms that we have in India, and why most of the SAP holders or or implementers have they really adopted or moving towards an ADR resolution technique. The overview of SAP litigation has essentially been a very litigious in terms of a dispute, in terms of dispute settlement. They have usually approached the Delhi High Court, and I wouldn't even say all the courts in India, pretty much, I think all SAP litigation have started before the Delhi High Court. And today we can kind of say that, Delhi High Court, it seems to be one of the most kind of forerunners in settling SAP disputes. And of all the SAP disputes that we have seen in India, 55% of those total SAP disputes have concluded, and 50% were decided prior to the commencement of the trial. 3 have gone to trial, Ericsson, and one of them is Ericsson, and 2 of them are Philips, cases for which patents were over. So what does this really indicate? It essentially indicates that, when you are looking at a dispute resolution mechanism, what is the impact of litigation that one could have on, particularly on SAP patents? Because when we see 55% of which 50% are already settled, even prior to the commencement of the trial, it does say a lot, which means that it could be considered as being I would say a mechanism to pressure the licensee to resolve, whether it is on a global FRAND license, or it could be on a very territorial jurisdiction, a territorial based licensing. But litigation does somehow give some kind of, and it is obviously you come to court only after there's a long period of negotiations which have kind of either been prolonged, or they've kind of fell apart, and that's when you come to litigation. Having said this, once you do enter a litigation dispute, a dispute between 2 parties, the SAP holder and the implementer, litigation does have the impact of giving some kind of an interim arrangement so as to secure the SAP holder, and at the same time it just builds up a pressure on both the parties. I wouldn't just say on the implementer. It also puts a lot of pressure on both the parties in order to resolve this outside the court, whether it's through mediation, whether it's through settlement, or whether it's through We haven't seen too many arbitrations here. I mean, not to my knowledge, at least in India. I'm sure they would have gone to, global license arrangements, because most of these settlements that have happened in India are an outcome of a dispute that's been settled globally. So maybe the implementer has secured a global license, as a result of which even the litigation, whether it's India or China or other jurisdictions, they pretty much settle down. The average time when we see a litigation is, for settlement of dispute. And when I say settlement of dispute, doesn't mean from start to finish. It pretty much means that you've not even commenced a trial and you kind of still at the very interim stage. It can take sometimes 2 to 3 years, because the issues we all know in SAP, FRAND is not the only issue. In a litigation dispute, there are many, many issues that, branch out of an SAP litigation, which could include, the nature of interim relief that you're seeking, confidentiality issues, anti-suit injunctions, anti-suit injunctions. So when many of these interim branches that come out of an SAP dispute do arise, probably if you have to look from start to finish of these entire gamut of reliefs, it would probably take 2 to 3 years. Of the majority of, I think there were kind of 40 disputes that so far have been filed. And these 40 SAP disputes in India cover more than 100 patents. So one dispute probably would have, maybe over five SAP patents that would be kind of filed. So for 40 disputes to my count, maybe it could be more, I could be missing some, with multiple patents covered in each of these disputes. Some could be common. They've been filed in the last 3 to 4 years. We've had the Philips case that was filed way back in 2010 and was decided after the term was over. Recently, another case on the codec technology, I think that was the DVD technology, that was again decided after the term of the patent, which was filed way before, much before when the telecom, I would say the telecom era set in into India. And as you know, Nishant also said, most of the SAP litigations filed after the prospective licensee is shown to be an unwilling licensee or no counter offer, or there have been delayed negotiations. Mr. Chawla did mention now about the Ericsson case. So there are certain, guidelines, or at least some direction that's been set by the court as to, when can you really approach the court in a dispute between the SAP holder and the implementer. Some trends here are, as we've seen, ADR, when we do talk about settlement or arbitration, pretty much that they're at the global level, and that's why we've seen a large number of these disputes being settled. So far, there's only been one pre-litigation suit mediation that's happened. That's of Nokia, and that's also in view of a unique provision in our legislation that was introduced by the Commercial Court Act, and that I'll come to that in a moment. With 35 to 40 suits, as I said, interim reliefs probably in 15. And when we do talk about interim reliefs, essentially, what does an SAP holder looking at? SAP holder is looking at some kind of either a pro tem, not so much an injunction, not so much a preliminary injunction, a pro tem bank deposit, or some secured guarantee, or at least some interim royalty calculation based on some global license agreements that they may have with other implementers. 3 decided. So some of the interim reliefs, as I said, include court deposit bank or bank guarantees, orders for direct payment, and undertaking to preserve money in bank and property. And one of these reasons for undertaking to preserve money in the bank and property is to ensure that in case the implementer in India goes bust, for instance, maybe for whatever reason, they shut shop, there's some tax related issues, there may be any kind, and we've seen that happen multiple times. At least there's some kind of a bank guarantee or security that the SAP holder has through a court order. Now, when we do talk of nature of SAP disputes and including arbitration or mediation, one of the very, very important things is what is the scope of an arbitration? When we do go for an arbitration, what are the kind of disputes that may arise? And to my mind, when I look at arbitration, I would pretty much, the disputes that can go to arbitration can pretty much involve FRAND determination, some of the violations of the clauses in a contract or an arbitration agreement, confidentiality issues, and maybe also looking at some kind of an interim arrangement with the implementer. when I do talk of item number 1 and item number 2, whether an arbitration panel can decide the validity or an infringement by infringement-related issues of an SAP, maybe to my mind, according to me, that may not be a possibility because these two issues have to be necessarily be decided by the court. Because a patent which is granted is usually a right in rem, which means that it's not in person and between two parties. It is a right in rem. So obviously, an arbitration panel does not have the jurisdiction according, and this is my view, as I said, jurisdiction to decide the validity of a patent through an award, an arbitration award. Similarly, when we do talk about essentiality, obviously there's no dispute. Maybe the implementer will have to kind of agree that it is an essential patent. Infringement, maybe the implementer has to, when there is a claim mapping and they're adopting a particular standard, it's deemed to be an infringement. So that would never be an issue before an arbitration panel. But if there is a dispute as to whether there is infringement or not based on claim construction, something like a Markman hearing, that is again something which is in a very specific domain of the courts in the country and maybe in other jurisdictions as well, whether the arbitration or not even a mediation or arbitration panel can decide issues of validity and infringement. So if 1 and 2 are settled pretty much with the implementer and the SAP holder, maybe the next step would be to try and see what are the alternate dispute mechanisms that are available to an SAP holder as well as an implementer. As Nishant said, they have to be willing to kind of enter into a discussion or a negotiation. So when the kind of some of the reliefs that we see in SAP litigation I've kind of dealt with these issues on interim arrangements, injunction, interim royalty payments, bank guarantees, settlement negotiations. There could be issues on related to competition. So there might be the Competition Commission of India playing a kind of a role that we've seen, Eric's, some of these Chinese companies going to CCI for abuse of dominant position by some of these SAP holders. There are issues that do arise, particularly during the interim stage, is on royalty-based comparable licenses where you have to set up a confidentiality agreement, and then at the interim stage, when you do provide comparable licenses, the courts can agree through a court mediation. The implementer and the SAP holder do agree for some kind of a arrangement, call it a FRAND arrangement or a special arrangement for the implementer. And then obviously looking at alternate dispute resolution, one of which also includes a pre-litigation. Now, what we see in India is that recently, since 2015, the mediation mechanism is being encouraged by the courts. And the reason why do I say this is that the Commercial Court Act of 2015 now has an inbuilt mechanism provision, which is Section 12A, which necessarily requires two parties to only approach the court in case an urgent relief is sought. And before that, they have to kind of exhaust this remedy of a pre-suit mediation. The other mechanism is not through a Commercial Court Act. Commercial Court Act obviously includes IP disputes as well, but this is generally, the Code of Civil Procedure, where under Section 89, even during the litigation, a court is of the opinion that a dispute can be resolved by settlement or by a settlement. The court can refer the dispute to outside the court, which can include arbitration, conciliation, and mediation. And the whole purpose, if we look at the statement and object of this provision of law, which is a kind of a very old provision, it is to encourage peaceful resolution without the court intervention. So these were some of the inbuilt mechanisms that we do have within the framework of our legislation in India, which kind of does give an indication that this is going to be, the way forward, and you have to kind of resolve all these kind of issues before you approach the court. Pre-suit mediation litigation, as I said, it's very, very unique, recently introduced recently, as in it's not been a very old mechanism, which is a very unique form of ADRs. Some of the pros and cons that Nishant did deal with. Nokia has been the only company so far that's availed of this provision, and it's been very successful for Nokia. And the time, it's basically facts speak for themselves. It was a dispute that was resolved within 8 months through the pre-suit mediation technique. Some of the pros and cons, which are similar to what we see in mediation and arbitration, is and not that I'm using them interchangeably, obviously mediation and arbitration kind of are very separate, but when we look at it, it's basically, two parties sitting down across the table and trying to settle something, either through a mediator or through an arbitration panel. Pros, time and cost effective. You have to come to the table when you're negotiating in good faith. And there is no threat to validity challenge, because whenever there is a validity challenge, obviously a pre-suit mediation is not an option that's available. And what it further helps is it ensures confidentiality of the terms and conditions of the arrangement that's been negotiated. And a neutral and independent mediator does facilitate discussions. A mediated settlement agreement can be enforced like a final non-appealable judgment of the court. The cons are that in case, obviously the negative of it is that in case the parties don't agree, you have the option of going for a full-fledged litigation. Pretty much, I'm going to skip section 12A of the Commercial Court Act because I've pretty much covered it in my earlier slide. But these are some of the, when we look at the purpose and the objective, whether it's a mandatory provision of law. Now, section 12A of the Commercial Court Act, which kind of defines a pre-suit mediation, has become mandatory through a Supreme Court order. And there are very few exceptions to the rule, exception being that you are seeking an urgent relief in the matter. And if you have seeking urgent relief, you can claim an exception to this rule. Arbitration and SAP versus life sciences. I just thought I'll kind of pick up this topic very briefly, because I think last year we did with WIPO and ICA and FICCI, we did a seminar on SAP in life sciences, arbitration in life sciences. And then, I just thought that if one could kind of draw a parallel between both of them, is it possible to draw a parallel between life sciences, arbitration and life sciences, and that in SAP? And one thing that comes to my mind is when you do look at the Indian, demographic or the Indian economy, the way Indians, I would say the generic being the largest generic manufacturer in the world, arbitration may not be an option for patent holders, particularly because it's very territorial in nature. B, the generics in India are very strong unless you're entering into probably a voluntary license. So way to go maybe in India, how life sciences agreements would operate would be very bilateral between two companies, the patent holder and the licensee, and special rates that are going to be set. So pretty much arbitration it's not like a mandatory, it may not be a preferred option for in that domain. Having said this, as I said, when we do talk of SAP is based on a premise that there is a commitment that you have to offer a licensee. So unless the validity and the proof of infringement is challenged, SAP does hold a lot of advantage, which Mr. Chawla, Nishant, and everybody have kind of dealt with it for SAP, as in swiftness in resolution, confidentiality. You don't see contradictory decisions. You would have pretty much uniformity in decisions. You can also select the arbitration panel of your choice, which could include, judges. You could include experts in patent law. You could kind of your choice, have economists to determine FRAND rates, and somebody obviously who is well-versed in technology. Issues like anti-suit injunctions or anti-suit injunctions can be, arbitration does minimize the risk of injunction and business disruptions. And one of these mechanisms of business disruptions, when we talk about, is like an anti-suit injunctions that can usually be granted by courts, particularly courts in India and also other jurisdictions. Low cost, high efficiency. There is a resolution with neutrality, and a global licensee can be obtained by the implementer, not only for SAP, but also NCEP. So for instance, you do go through an arbitration. It's not for a limited, like Nishant said, it's not just for a limited number of patents that for which you're seeking a license. It can be extended to cover other technologies. It could be extended to cover other devices. It could be covered, extended to cover other jurisdictions. It could be extended to cover even NCEPs, non-essential patents. So that flexibility does, you do have that flexibility in arbitration, and that can be that can be resolved through this mechanism. Nishant kind of brought up a very good point that, and honestly, I was not aware of this, so much aware of this point of tiered royalty depending on the jurisdiction, because you may not want to fix up a global royalty, a company, the implementer may not agree to a global royalty depending on, the jurisdiction where the product is being sold. So arbitration again gives the ability, and I think there is options that are available for jurisdiction and a tiered royalty, where if it's a developing country or least developing country, based on the usage, based on the volumes, based on the numbers, based on the number of patents, you could kind of create those categories for royalty payment on FRAND terms. Some of the challenges are these challenges. I think, like all other arbitration and mediation, are both parties have to agree to come to terms and sit across the tables. There is no compulsory enforcement of an arbitral award, and unlike court proceedings, there's always a very limited discovery of documents like comparable licenses and things of that kind. The issue, as I said, ADR, you have to come for an arbitration or reach out for an arbitration only when you are sure that the validity there is no challenge to validity, and obviously there is a implementation of the SAP essentiality being used by the implementer in their devices. So pretty much, I just thought that I would like to cover some of these issues very broadly in these 15 minutes to be able to just give you a perspective of where we are. Is it still being preferred in India? Not for a moment I'm saying that arbitration is not something which is preferred. We've got one of the largest now arbitration centers in the country, and even the government is promoting arbitration. But most of these settlements that we have seen of SAP disputes are as a result of, may not be arbitration, but as a result of a global license settlement agreement, which may have happened at a global rate. Thank you so much.
Thank you, Ms. Shanker. Those were really insightful and thought-provoking observations. Like I said, we will take up, we have a lot of questions already, and we shall take up the questions towards the end of all the sessions. The next session will take you through the WIPO Arbitration and Mediation Center Overview and SAP FRAND Case Experience. It is my pleasure to invite Dr. Heike Wollgast, Head IP Disputes Section at the WIPO Arbitration and Mediation Center, Geneva, Switzerland, to share her valuable perspectives. Dr. Heike Wollgast oversees the administration of WIPO mediation, arbitration, and expert determination cases, and leads legal and policy developments relating to WIPO alternative dispute resolution. This includes the development of ADR schemes adapted to specific industry sectors, as well as ADR collaborations with IP authorities and courts globally. Dr. Wollgast is a German lawyer and holds a PhD in European Community Law from the University of Cologne. Following studies and legal training in Germany, Switzerland, and the US, she practiced with two major law firms in Germany in the areas of IP and trade law. Before joining the WIPO Arbitration and Mediation Center, she also specialized in international IP enforcement law and policy at WIPO. I would like to call upon Dr. Wollgast now to share her observations, please.
Thank you. Thank you very much. And good afternoon or good morning to all participants. I'm very happy to now take over this session together with my colleague Isha Singh, who is a lawyer in the WIPO Arbitration and Mediation Center, who helped me preparing for the session here today. So let's start just briefly about the WIPO Arbitration and Mediation Center for those of you that are not familiar with us as an institution. So we are part of WIPO, the World Intellectual Property Organization, and really the center was set up more than 30 years ago to help companies, involved in any type of IP or technology related disputes, to help them resolve their disputes outside court litigation. Of course, there are other mediation and arbitration institutions. Previous speakers already mentioned some other options. I think what are the main features of WIPO mediation or arbitration are first the international neutrality of the WIPO Center as a forum, and we see this especially in the SEP and FRAND context when we speak with the companies that are involved, that they choose the WIPO option in the situations where they're looking for an internationally neutral forum. And the second main feature of the WIPO Center is of course our specialization over all the years, in anything relating to IP and technology and patents. And that is reflected especially in the global pool that we have developed over the years of mediators and arbitrators that now covers more than 2,500 mediators, arbitrators, and experts, including a specialist of neutrals that we have developed for SEP and FRAND disputes. And of course, this global pool includes a good number of mediators, arbitrators, and experts from India. Next slide, please. So here just a snapshot of our general evolution of the caseload, and I think I just wanted to share one message from that evolution. Clearly, we understand that mediation, arbitration are better and better understood, by companies and their lawyers. So clearly, our caseload is growing. The majority of these cases are mediations. So I think this is also something that where we see a lot of dynamic. We understand also that courts in many jurisdictions are very much encouraging the use of mediation, and clearly that is reflected in our caseload. Next slide, please. We can skip that slide, but we go directly to the next one. So just very briefly about the WIPO rules. Of course, they're available online if you're interested in taking a look. I just wanted to highlight again, of course, they were drafted and have been updated ever since, having specifically IP, patent, and technology disputes in mind. So they have a series of provisions that can be useful for patent-related disputes, including SEP-related disputes. And I just wanted to highlight the point of confidentiality. Both the mediation but also the arbitration rules already include quite a detailed set of rules, how to deal with confidential information. Of course, in the SEP context, this can relate especially to comparable licenses or other confidential information. Also, the existence of the proceedings are protected under the confidentiality rules. So in our case experience, we see that in most cases, the framework that is already provided under the rules is sufficient for parties. But of course, if they wish to have additional layers, they can also conclude confidentiality protocols. And we see that this sometimes happens also in the FRAND SEP context. Next slide, please. So if we now zoom in a little bit more about concerning SEP and FRAND disputes, I think the benefits, as now if we compare mediation, arbitration with litigation, I think both Archana and Nishant have already mentioned a couple of points here. I think I just wanted to mention a few. So the first point was also mentioned by Nishant. Whether it's mediation or arbitration, of course, the idea is that an agreement on FRAND rates is being achieved or facilitated, and that, of course, can have an impact on the business relationship between the patent holder and the licensee. I think that the nature of ADR proceedings very much encourage settlement. We have in our own caseload in the WIPO mediations, we have a settlement rate of about 70%. So 7 out of 10 mediations result in a settlement, and that also concerns SEP and FRAND cases. But even in WIPO arbitrations, more than 1/3 of the arbitration settle. So I think the dynamics of the proceedings very much promote the agreement. I think the other points have been mentioned already. Since any type of ADR is based on party agreement, parties can agree on the scope of the jurisdiction, so they can if that's what they wish, find a solution of the dispute at a global scale. They can also agree on the scope of dispute, whether they want to include all claims or defenses or wish to limit them, whether it should be the entire patent portfolio or only parts of it. They can agree on stages. There are plenty of options, and we make available some resources to guide parties that want to look into this, and I will have more information about this in a minute. I think quite important is the point of expertise, which was also mentioned before. In a mediation or arbitration, parties are able, with the help of the institutions, in our case with our support, to identify mediators or arbitrators that have a fundamental understanding, not only of the legal issues at hand, but also of the commercial context, to be able to help them in mediation to find a settlement, or in arbitration to make the right decision. If we go to the next slide. So we now look at our own caseload in WIPO cases. So we have seen really quite a strong growth in our caseload concerning SEP FRAND disputes in mediations. We have not seen many arbitrations so far. I think also, having listened to the previous speakers, that may change, but for now we have seen a particular uptake of WIPO mediation. I think there may be many reasons. Of course, in a mediation, parties retain full control. They can also terminate the proceedings. So perhaps it's a bit easier to agree to try mediation. And again, with also the high settlement rate that I mentioned of 70%, many disputes end there, and parties do not have to go to the next stage, whether that's arbitration or litigation. So if we look at our caseloads, so we have administered about 85, a bit more by now, SEP-related mediation so far. These cases have involved parties from more than 20 jurisdictions across Asia, Europe, and North America. We've also seen the whole range of players involved in these cases: SEP holders, implementers, and also patent pools. Nishant spoke about pools in the first presentation, and when we see that they're also quite actively using mediation, and I will have a case example about that in a moment. Very often in the cases, mediation is commenced when court litigation is already pending, sometimes in just one jurisdiction, but in many cases already in several jurisdictions. We make available a whole series of resources to help, especially smaller companies that are not so familiar, with the available options and how to tailor them. We have developed with an expert team model submission agreements and clauses. They're all available on our website in a number of languages. So please feel free to take a look. And just the last point on this slide to mention that we also see growing interest by member states. Of course, with being part of WIPO, our stakeholders are member states in 193 jurisdictions. And we are quite actively working currently with the IP offices of Canada, of the UK, and also in the US to promote the use of ADR in the SEP FRAND space. Next slide, please. So here you just have a quick graph that shows the different options that can be used and are being used in our caseload. Of course, there can be a clause already in an agreement, and we see this sometimes when there's a situation where two companies already have agreed on a FRAND rate, or there's a licensing agreement, and that now needs to be renewed. And of course, in that licensing agreement, there can already be a mediation or arbitration clause included, which then facilitates, of course, the submission. If this is not included, and if parties can't agree, I just wanted to mention that it is possible under the WIPO rules, and we see this being used a lot in the SEP context, is that one company can file a request for mediation with the WIPO Center unilaterally. In a way, it's an invitation to the other party to mediation. And then what we would do is we reach out to the other party and then just inform them, that party A is interested in mediation, and we ask them if they wish to join the mediation. Of course, if the other party says no, then the proceedings would terminate there. We cannot force anyone, of course. But what we realize is that at that stage, we are available as an institution, to share information about the procedure, how would it look like? We can reply to questions like, where would the mediation take place? Who's the mediator? What are the languages? Which would be the cost and questions like that. And we have found that this is really helpful to enable both parties to decide whether they wish to proceed with the mediation or not. And as I said, we have seen that this has been used quite a lot in the SCP and FRAND context. So let's perhaps then move on to the next slide. I think we can skip that. Let's go to the next slide. So here, this is just a copy or an example of the form for this unilateral request. It's available online. So please feel free to take a look if you're interested in that option. And before handing back to the moderator, I just wanted to very briefly share with you 3 case examples to illustrate a little bit to illustrate some typical examples of cases that we have administered. So the first example is a WIPO mediation relating to SCP FRAND licensing and negotiation. So in this case, we had a large patent holder from a telecommunications company in Asia. And on the implementer side, it was a smaller, I wouldn't say an SME, but sort of smallish electronics manufacturer based in Europe. There was already litigation pending in some jurisdictions, and the dispute was really about appropriate licensing terms related to some wireless communication technologies. Parties here agreed jointly to submit that dispute to WIPO mediation. So we have received that form signed by both parties. And then we proceeded with the appointment of the mediator from, as I was explaining, our special list of mediators for SCP disputes. That's just one comment here. So we don't just go ahead and appoint, but there's always a consultation with the parties. We call this list procedure. So we also ask the companies, and their lawyers, what exactly would you like the mediator to bring as qualifications, as experience, and then we take this into account by proposing candidates. And then the mediation started. There were, as usual, a couple of virtual preparatory meetings. We see this almost a standard practice now these days, and we help supporting these meetings online. And then there was a one-day in-person session where settlement was almost reached, and then followed by another virtual session, and the case settled within 6 months, when parties were able to conclude a global license, and the lawsuits could be withdrawn. If we look at the next case example, I don't know, Ruchita, are you saying something? I can't hear you. Otherwise, I will just conclude.
I think you can continue.
Yeah, I'll just conclude with the 2 last examples quickly. So this is the second example. This is another typical examples where we really had global players involved on both sides. One party European, the other one from a country in Asia. It's typical, one of these large disputes where litigation was pending in multiple jurisdictions, again across countries in Asia, Europe, and also some other places. Here it was not only the SCP holder and implementer, but it was a cross-licensing situation concerning the parties' global portfolios of cellular SCPs. Here again, they agreed to jointly refer the matter to WIPO mediation. We appointed a mediator who was bilingual, English, Chinese, which was very useful in the conduct of the mediation. Parties were very concerned with confidentiality, so the mediator helped them, and then we also helped establishing a confidentiality protocol to manage certain highly confidential submissions. Parties discussed the appointment of an independent expert to help them assessing certain parts of comparable licenses, but ultimately that was not necessary. And again, after a couple of virtual mediation sessions and also separate sessions with the mediator, parties continued their negotiations and reached a global patent cross-license agreement. And then the last case example, just very briefly, it involves the patent pools. I thought it could be useful as a different case example. So here we had a patent pool administrator based in a European country, and on the implementer side, an Asian electronics manufacturer. Again, negotiations concerning the appropriate licensing terms, in this case for digital broadcasting technology or patent. In that technology, there had been license offers and counter offers and follow-ups, but no agreement could be reached. Here, the pool filed with us the unilateral request that I was describing just before. We then reached out to the other party. We explained the procedure. And what happened here, and that's something that we also see quite often following this unilateral request, is that parties sort of revived the negotiations and they informed us, well, let's wait a little bit with the appointment of the mediator. We will try to settle between us directly. And in this case, this is what happened, and they managed to settle directly, and we could terminate the case after that. And I think I'll conclude here and then leave it at that and hand back to the moderator. I'm very happy to take your questions afterward. And of course, there's a lot of information on our webpage also. Thank you very much.
Thank you, Dr. Wollgast, for enlightening us with your experience and vision. May I now call upon Ms. Isha Singh, Legal Case Manager, IP Disputes Section, WIPO Arbitration and Mediation Center. She administers international arbitration and mediation cases relating to IP and technology under the WIPO rules. Ms. Singh is a dual licensed attorney in India and New York and holds an LLM from Georgetown University, Washington, D.C. Her areas of expertise include intellectual property, ADR, life sciences, food and drug regulation, global health law, and governance. Over to you, Ms. Singh.
Thanks, Ruchita. For the paucity of time, Heike and I decided to merge our presentations, so she quickly went over what I had to present. And with that, we can hand it over to John to share his insights on the use of mediation for SEP and FRAND disputes.
Thank you. Morning and afternoon. I think we're probably quite short of time. Can everyone hear me okay? Is that the other? Yeah, okay.
Yes. John, would you like to briefly introduce yourself? We skipped your introduction.
Let me do the honors, please.
Oh,
okay.
Okay, I'll shut up.
So our concluding session focuses on demystifying the mediation process for SEP FRAND disputes. And it's my pleasure to invite Mr. John Lang, mediator at IPOS Mediation and the International Dispute Resolution Center, United Kingdom, to lead this session. Mr. Lang is one of the UK's most experienced and highly ranked commercial mediators, consistently recognized in the top tier by chambers and partners, Legal 500, and featured in the International Who's Who of Commercial Mediators. A CETR accredited mediator, Mr. Lang transitioned to full-time mediation in 2005 after nearly 20 years as a solicitor, including 6 years as partner in the disputes group at White & Case, London. He has successfully mediated hundreds of complex multi-party domestic and international disputes involving cross-border trade partnerships and tailored dispute resolution processes. A former chair of the IBA Mediation Committee and a member of CPR's panel of distinguished neutrals, Mr. Lang is also recognized as an expert in mediation, renowned for his calm, strategic, and solutions-oriented approach. He remains a trusted name in high-stakes commercial dispute resolution globally. We are eager to hear your thoughts. The virtual floor is yours.
Thank you for that very generous and kind introduction. Look, I'm going to perhaps dart around a bit by picking up a few comments that I've already heard, because I think that may sort of set the scene a little bit. The first comment, though, is that mediation and arbitration are not mutually exclusive. Both processes can be used. Mediation and litigation are not mutually exclusive. Both processes can be used. And when I'm mediating intellectual property disputes, more often than not, there is already litigation on foot. There were some very generous introductory remarks, which I'll come back to, but just one on enforcement. The New York Convention was mentioned, the 1958 New York Convention about enforceability of arbitral awards. And Nishant refers to the sort of sanctity of an arbitral panel, perhaps favouring arbitration over mediation. Well, look, just to mention that a couple of years ago, the Singapore Convention was brought into play, and a number of countries, hundreds, are signatory to that, which provides for the enforcement across borders of mediation and settlement agreements. Frankly, I'm not sure it's going to make all that much difference, because I don't really see much difficulty with people honouring settlement agreements arrived at mediation, and that is because it is the parties' solutions rather than a solution imposed upon them by an arbitral panel or a judge or a panel of judges. In terms of costs, when I was in private practice, I never saw much difference between the cost of an arbitration and the costs of litigation. Both were huge. Compared to mediation, it's a fraction of the cost. And I'd urge everyone to give mediation serious thought, particularly when they are involved in a FRAND type issue, because to my mind, mediation was built for FRAND disputes. It's perfect. It's a perfect process to explore the possibilities. And I think that's borne out by the settlement rates that Heike talked to, 70+%. That's 70+% of parties generally probably being quite happy with the outcome, as opposed to one being imposed upon them. Mr. Chawla mentioned that mediation was not a soft option, although to be fair, I think he was talking about ADRs generally. And mediation absolutely is not a soft option. And I just want to deal with a couple of basics. So because that really informs the point why it's not a soft option. A FRAND dispute, even on rate. So before you usually get on to have a hearing before a court or an arbitral panel on FRAND terms, and it's not necessarily just rates, but rates usually form the most significant part of the debate. You've got to have a number of sort of what people often refer to as technical trials. You know, you've got to sort out validity, you've got to sort out essentiality and infringement. But even a FRAND, once you've done that, a FRAND discussion before a court or an arbitration could take 2-3 weeks. At a mediation, you're probably sorted out in 1 day or 2 days. If you don't get a resolution on those 1 or 2 days, you're probably going to get one within a week, 2 weeks thereafter. But at mediation, there's no judge or arbitrator to find against your opponent. You've got to bring your opponent along with you, which means it's a completely different type of approach. It's not similar in any way to the adjudicative processes of arbitration and court, where you're appealing to an arbitrator or a panel of judges or a judge to knock your opponent out of the game and agree with everything that you say. At a mediation, of course, you want to get your best deal possible. Lawyers want to get their clients the best deal possible, but they can only do that by getting their opponents to say yes to the same terms that they are prepared to agree to. So the trick is to formulate a strategy to do that, to get the other side to agree with you. So it needs a completely different approach. You're not appealing to a third party to make a decision. You're appealing to those that you're in difficult circumstances with, because you haven't agreed a FRAND rate. So you need to influence them. And once you know how to influence those on the other side of the fence, that gives you the real power on the day or the day. So it means adopting a style, content, delivery of key messages in the most effective way, in a way that's going to be most readily absorbed by those on the other side. So it's a greater subtlety of approach. It's moving from attack to justification. It's moving from imposition to explaining. It's moving from bluster and bluff, if you like, to logic and rationale. So it's absolutely not a soft option, because to get all of that done in 1 or 2 days, to replace what might be a 3-week FRAND rate trial, that takes a lot of thinking about. So it's a sort of thinking about measured diplomacy. Now, look, why is it suitable for FRAND disputes? Well, look, an implementer needs to take a license if they want to use a particular standard, assuming that they accept or do not want to challenge the validity and essentiality of the patents that they will employ in implementing the standard. They're going to have to do a deal with the patentee, the IPR owner, and the IPR owner has to do a deal with the implementer. That's part of the deal when they make a declaration to a standard setting organization that their patent or patent portfolio is essential to a particular technical standard. The deal is they'll license on FRAND terms. The difficulty is working out what FRAND terms are, okay? And we all know what FRAND stands for. So the implementer is entitled to say, I do not want to be discriminated against. I want to take a license on the same terms as everyone else. They've got to be fair and reasonable, of course, but I don't want to pay more. And there will be a debate about that. And if it ends up before a judge is going to have to work out what a hypothetical license rate and license terms look like between, in effect, a license, a willing licensor and a willing licensee. What's the FRAND rate? Now, I think Nishant mentioned perhaps one of the drawbacks of an arbitral panel is the expertise. Are you going to be able to find an arbitrator in your territory, maybe others, who has that kind of expertise to work out what the right hypothetical FRAND rate is? Well, at mediation, you don't need to worry about that. The parties are there. The parties are the experts. And if it doesn't work, you've always got arbitration and litigation to fall back on, but you keep it in-house, as it were. So I think that mediation is built for FRAND disputes. So what do we have to think about? When the parties decide to mediate, we're going to need to think about the nature of the discussion. We're going to need to set up a process that works for them. And I think Heike in her slides was showing the kind of things that happen. And absolutely, I will meet with each side separately, and I will meet with the parties together as well. Because what I like to see when I go into a FRAND mediation is as much worked out as possible. And it's not just the FRAND rate that has to be fair, it's the FRAND terms as well, the whole license. So one of the things that I often encourage in IPR disputes generally, in fact, but particularly FRAND disputes, is parties start to work on a traveling license agreement. They work out the terms. What's the term? What's going to happen to past sales? How far back do you go? Is there going to be interest charge on on past sales license? What products? What territories? All these things can start to be thought about and negotiated in a traveling draft of a FRAND license prior to the mediation, which usually is talking about the most difficult area, and that is the rate per unit, or however else you want to decide on the FRAND license. So as much should be sorted out as you possibly can. Now, one of the reasons why I think mediation is so suited to FRAND disputes is that when a court is asked to determine the FRAND rate, what they've got to do, and what they usually do, is to look at comparables, comparable licenses, other licenses that have been agreed, okay? Now, just to step back from FRAND, I mediate all the time. So that's all I do all I've done since 2005, just mediate. But one of the most powerful tools at a mediation is the employment of objective data. So when we negotiate, we have this kind of inbuilt bias where we dismiss anything that comes from the other side, because they would say that, wouldn't they? They obviously want to get the lowest rate, or they obviously want to get the highest rate. The employment of objective data is so important at mediation, but so important at a FRAND mediation. If I'm buying a second-hand car, I'll try and find data, so looking at the model, the mileage, the year. If I'm negotiating, mediating a shareholder dispute, someone who's got a small shareholding and they want to exit the company, there'll be a minority shareholder action, there'll be discounts for the minority shareholder. You look at the rates, the percentage discounts for minority shareholdings that have been awarded by the courts before. It's all about objective data. And I think that's what the courts try and do by looking at comparable licenses. Now, these can be licenses between the patentee, the IPR owner, and other licensees that they've got a license from. It can be between the parties themselves for older technology, which just needs to be renewed. It can just be completely third-party licenses. Obviously, there's a difficulty getting information and data about those other third-party licenses, but sometimes people refer to patent pools and the information that's published about that the entire patent stack that can be licensed through a patent pool. But most of the time, a court will be looking at comparables, and there will be very well rewarded experts who have unpacked those comparables. That's essentially what we will do at a mediation. Most of the issues about term and interest and limitation periods, how that comes into play, etc., and the kind of products and the kind of territories will have been worked out in advance, or we know where the bookends are. And it's, you know, one of two or three possibilities. It's UK, Europe, US, Asia, or whatever it is. So it's really about unpacking those comparable licenses. There will be a discussion about which licenses are truly comparable. And there will be some debate about that. And that's the kind of discussion that could be happening on the way into a mediation. So at a mediation, what typically happens is there is a deep dive into comparable licenses. And beforehand, people will prepare slides explaining how they've unpacked various comparable licenses to arrive at what they suggest is a FRAND rate. Now, usually, or quite often, there's not too much difficulty in working out what a comparable license is. The real argument is about how that comparable license is unpacked to come up with a FRAND rate, okay? And that's what a lot of the time at a FRAND mediation is spent doing. But we don't, experts have sometimes prepared reports, sometimes they haven't, but there will be explanations as to how people arrive at their FRAND rate, and the discussion will focus around that. And the beauty of mediation is that everyone's thinking about the same thing at the same time in real time. So what might typically happen is that one side will give a little presentation, a slide stack of 15 or something, showing the various stages of unpacking a comparable license, and that's typically called a top-down approach. And they will strip out all sorts of things, and they'll work out rough sales and territory, and the other side may not like it, and they may argue that whatever rate you come out with isn't a true FRAND rate, because there were particular features of that license that separate it, distinguish it from the license that we are trying to agree in our dispute. So it might be that a particular licensee got a discount because they were the first entity to take a license, and IPR owners quite like sometimes to reduce the cost, if they can, of a first mover to encourage others to join and take a license of their products. Sometimes there might be an argument that the IPO owner had undue weight over a fairly small licensee and could use, hold up techniques. So there's all sorts of unstripping of particular features peculiar to those comparable licenses that need to be discussed at a FRAND mediation. But the key is you've got the right people in the right room or rooms thinking about the same thing at the same time. And I find in any kind of negotiation, but particularly in intellectual property disputes, and particularly FRAND disputes or patent disputes, the parties will have very, very experienced expert evidence. Usually I'll see that in advance. And we all know, and I mentioned it earlier, the confirmation biases that we have. The more something is written down, the more a party spends on an expert report, the more they've paid. These things could cost hundreds of thousands of dollars because they're done by economists and all sorts of licensing experts. The more wedded they are, the more certain they are that they've got to be right. How can something so beautiful, so expensive, possibly be wrong? Now, look, in normal bilateral negotiations, what usually happens is parties see their expert reports about the unpacking of comparable licenses and the coming up of a FRAND rate. And because they paid so much for it, they'll stick to that. But at a mediation, you tend to sort of break down the barriers because you've got senior people there, as I say, thinking about the right things at the same time, and with the aim of getting a deal in a very short space of time. So, look, I don't know whether there's anything that you want me to cover. I mean, confidentiality is a big issue. If there is litigation already on foot, usually there has been some kind of confidentiality ring established by the court, and things are relatively straightforward and clear as to what can and cannot be discussed. What sometimes is a little tricky at a FRAND debate, FRAND mediation, is there might have been disclosure of comparable licenses. Those comparable licenses might only be seen by the external lawyers. There's various grades, in my experience, of confidentiality ring. What is an even more difficult area is the negotiation materials that went in to find the basis of that license. Okay, so there's always going to be a degree of extrapolation. Quite often there's public data about the level of sales and markets and stuff like that. But that's kind of where the debate centers at a mediation. It's not usually about validity. It's not usually about essentiality. And I think the comment's already been made. If you're going to argue about that, you probably need to have a court hearing. It's not something that you want an arbitrator or even a mediator to deal with. I mean, these are rights against the world. You know, in REM, you know, whatever deal was hatched at a mediation wouldn't affect the validity of a patent as against the rest of the world. Might restrict what parties themselves to the mediation agreement might be able to do, but it wouldn't affect what the enforceability of that patent or the invalidity or whatever of that patent as against the world. So confidentiality is something also that is worked out, but that's always done in advance of the mediation day. So we clearly know who can see what. And sometimes we have to be careful about who's actually in a meeting, a particular meeting at a mediation, if they're not part of the confidentiality ring that sees particular very, very sensitive and confidential information about a third party license. But, you know, by a process of offer, counteroffer, explanation, challenge, usually parties advance the debate about the FRAND rate, and also sometimes the wider terms of a FRAND license about term, territory, what you do about past sales, blended rates, and it can have jurisdictional spread across the globe, of course. Anything is possible, and you know, a judge is not going to be able to get into any kind of cross-licensing solution, which is often a discussion at these kind of mediations. So compared to court, I'd say a judge is a bit of a one-trick pony, really. At mediation, you can do anything you want, as long as it's legal and ethical. So look, that's what a FRAND mediation looks like to me. It's usually about the rate, but other things can come into force. It's not about validity or essentiality. Those things are either put on hold or have been decided already. I don't know whether I'm conscious of time and we've run over, and I know that you want to get questions done. So I'm sort of pausing here. And I don't know whether there's anyone, thinks that I should cover anything else. I just wanted to give an overview of sort of mediation as a comparable to arbitration and litigation and the kind of things that are discussed.
Thank you for sharing your expert insights on the evolving role of mediation in commercial conflict resolution. And after those intellectually charged session, we should, I think, now transition to question and answer round. So we have a lot of questions already, and I think I will go panel wise and then followed by a few questions which are common to all the panelists. For Mr. Sharma, there are a few questions. The first one is what we have seen that many times in patent pool licensing, some patents are SEPs, whereas some are not. What is the solution that you suggest? That is one question. And the second is how do SEP holders claim to comply with FRAND obligations when they withhold information such as comparable licenses, royalty calculations, etc.? And does this deliberate opacity skew the bargaining process, placing implementers at a systemic disadvantage and effectively enabling SEP holders to extract supra-FRAND royalties under threat of injunctions and litigation?
Okay, so answering the first question on maybe some of the patterns in a pool are not essential. So I already talked about an essentiality analysis being done by most of the pools before they take in those patterns into the pool. So in that sense, you can always ask the pool for the essentiality evaluation reports, and the pools would be happy to share that. So you are in a way assured that the patterns that have been included in the pool are essential for sure. So I haven't heard of, and I think, again, coming to the next question as well, which I believe a lot of it is based on conjectures. I haven't seen anyone complaining that a pool patent is not essential, even though it is claimed to be essential. I haven't come across any such instance. Maybe I would request the people who have raised these questions to share any examples if they have, or else the knowledge behind this particular question, because I am not aware of this. Coming to the other question on the opacity part and non-sharing of comparable licenses. So I think first of all, what we need to understand is this is a business transaction. What you are asking for is a comparable license, which includes the confidential business information of your own competitor. So what I've observed, and this is a practical example, in our discussions, we also ask the licensees to share their comparable licenses of any equivalent technologies that they may have taken a license on, so as to judge as to what is the rates they have paid for a particular technology. If you are asking for an information, you should always be open to share that information. You are, after all, entering into a business transaction. You expect the other side to behave in good faith and share all the information, which is confidential. So the experience has been the other side always refuses to share that information, and the reason behind that is confidentiality. So if something is confidential for you, something else could be confidential for me as well. Now, how do you resolve this dispute? And why is this a problem? Because all the license agreements would have information regarding the future sales projections of the competitors, the rates that they are selling their devices on, or maybe any other information which is business intelligence, and you are trying to get access to that, and there's no control over how that information is being shared within your company. So I have to ensure that that information of your competitor doesn't go so easily to you. What is the resolution for that? What is the solution? You either go to a court. In litigation, the court already established, the courts, as John mentioned, sometimes the court would establish a confidentiality regime where all these confidential agreements are shared, or you enter into ADRs. So today we learned about ADRs, wherein all these agreements are shared with the mediator, and the mediator can help you decide the rates. But giving an access of some confidential information, business intelligence to you, to the other side, it doesn't work in, you can call it as opacity, you can call it as anything, but that doesn't work under the principles of good faith. What the implementers are also mature business organizations. They have been in the business for quite some time. They know what is the applicable rate. They can make their own analysis, and this has been held in various judicial decisions as well, wherein the courts have said that the implementers are mature enough to find out what is the applicable FRAND rate for them. So asking for all these information while I sit with my hands folded waiting for the information to come doesn't help in any business negotiation as such. Now, there was also an aspect of the question also says that there is a threat of injunction and litigation. As an SEP holder, I would just like to clarify that as an SEP holder, I have very limited rights in respect of enforcing of my patents. My first and foremost duty is to offer someone a license. And I'll, again, another practical experience. Whenever an SEP holder would have litigated, you would have to, if you go through the entire history of that negotiation, you will see that the negotiation would have gone for at least 4 to 5 years. So this is the time period that a SEP holder waits to get the other side on board for a license. And then in the end, the other side doesn't share their own information, the relevant information for entering into a license. And then there's no option left for the SEP holder but to go into a litigation. But giving the reason as non-sharing of information and a threat of litigation as skewing the market, I don't think that reflects the true or the exact picture of how an SEP licensing goes.
Thank you. I have a few questions for Ms. Shanker. Why there is no compulsory enforcement of arbitrary awards in India? Is it consistent with New York Convention of 1958? That's one question. The second is, knowing that arbitration and mediation constitute flexibility of litigation settlement, why dispute settlements take 2 to 3 years before resolving matters related to said problems?
Thanks, Ruchika. I think the reason, when I have to address this question, essentially it becomes between two parties whether they're willing to negotiate on a particular standard, whether it's a top-down approach or a comparable license. So they have to come to terms. There has always been a negotiation history in the past, which could run into a couple of years, as Nishant said, before you do come to terms. I would use the term settlement because settlement could be either through an arbitration or through a mediation. It could be either one of them. So enforcement, and when most of these settlements, as I said, we've seen is a global license settlement, which is only between the two parties that are part of that part of the dispute. So the question here is not whether an arbitration award can be enforced or not. We're already a part of the New York Convention. India is already a part. So I don't think there is any true opinion as to whether that an award issued by an arbitration panel can be enforced or not. The question is whether SEP holders or implementers are opting in India particularly a route such as a mediation or arbitration to negotiate and settle a royalty payment term agreement between them.
Thank you. There are a few questions that are common to both of you. One is, how far along are we in India in using mediation in IP disputes and specifically in SEP FRAND negotiations? And second is, it was mentioned that rates are different for the developing countries and the developed countries. In practice, can it lead to enough differences in price to give rise to, for example, a problem of parallel importation? I think this could be a common question for all the
Nishant, would you want to go first?
Yes. Maybe I'll take the second one, because I am the culprit for that. So when I say there are two different rates, it is in recognition of the difference of economies of the developing countries and developed countries. In respect of how it may the problem of parallel importation, I think we still have relevant laws available within all countries to in a way bar parallel importation if it is happening in that respect. Also, I think the license also covers the terms of license also takes care of these requirements. So only if you are selling in India, then only you are paying that particular rate. If you are selling it somewhere else, then you are paying a different rate. But again, if there is a case of parallel importation that comes to the notice of the licensor, I believe it can be dealt with under the terms and conditions of the license, because there are relevant provisions available generally in a license to take care of all such situations.
And just to kind of answer the first question as how many cases why don't most implementers or SAP holders see mediation, I think it's very important to go back to see that how many years have they been in negotiations. Particularly in the Ericsson case, what they have the court has settled down that there has to be like an offer and counter offer. So you have to demonstrate when you come to court that there is an unwilling licensee, because either the licensee has been quiet for the longest, the prospective licensee has been quiet, or there's no counter offer that's been given by the licensee during the negotiation period. So maybe one of the reasons why in SAP litigation, mediation may not be the first option is because a settlement to agree on a FRAND term has already been ongoing for a longer period of time. And it's for this reason that they have to kind of approach the court in order to get these issues settled. And it's quite possible that it goes through a court-routed mediation as opposed to a private mediation. So unlike other technical domains in SAP, there is a history that's involved. In that history, you can't go on forever, on a negotiation without even arriving at some kind of a settlement or some kind of rates for FRAND determination. And that's the reason maybe if mediation, I'm not saying it's a closed option, but it is something that it can be explored even where there has been a long negotiation history. But one of the reasons is that it has gone for years. It's gone back and forth with claim charts, claim mapping, trying to settle on a FRAND rate for a particular jurisdiction, not agreeing on a global FRAND rate for a pool of SAP patents. So there are many issues and many challenges that are involved during this entire process.
And maybe just to add to it, the other aspect is obviously the other side has to agree to mediation. So often there are times when we send out a notice letter and we don't hear back from the licensee, or there is a long silence. So do you believe that the other side is willing to have a mediation or willing to agree to a mediation? Maybe not. So again, it all depends on the willingness of both the sides.
Mr. Lang and Dr. Heike, would you like to comment on the differential rate question?
Can I go first, John? Perhaps just very briefly, I would like to just comment on what Nishant was just saying, and also Archana touched on that, and I just confirm from our case experience. It's true that we see many of the mediation, SEP mediation or FRAND mediation cases, especially if they involve larger companies. There has been a lot of negotiation, before the mediation was filed. So I think as Archana was saying, there's often a bit of a history. Sometimes there's already court litigation pending. But nevertheless, once they agree, to move to mediation, we see quite positive, quite good settlement rates, good outcomes, but also in terms of time. It can then go relatively quickly. I had in my case examples, you've seen something like 6 to 8 months is a very realistic period for a FRAND mediation once it has commenced. But as Nishant was saying, of course, both parties need to embrace the mediation and agree. And perhaps on that, and another comment just on that, as you were saying, sometimes there's a situation that the SEP holder sends a notice or even proposes mediation, but there's no reaction from the other party. And I just wanted to mention again what I explained in my presentation, that at that point the involvement of an institution can be helpful through this unilateral request, to formalize that willingness to mediate. And we see some companies making use of that quite systematically, and then we can reach out to the other party. But in any case, whether it goes forward or not, that party that proposes mediation has sort of a record, where it can demonstrate its willingness to mediate or find an amicable settlement. I'll hand over to John for additional comments.
Just a couple of very quick comments. Quite often, there will be a timetable imposed on the parties by courts, and they know that in 9 months' time there is going to be a trial on the FRAND rate, and they will work and negotiate to that timetable. So they will mediate beforehand to save themselves all of the costs and uncertainty of going to that trial. And if it doesn't work, they know that there is a date in the diary. As to differing rates, it's not unusual for parties to negotiate around major markets, minor markets, different kinds of territories, and sometimes they'll talk about a blended rate, particularly in relation to sort of past sales. So there's no standard way of dealing with FRAND here. Courts have taken a slightly different approach as well. Certainly in the UK, we've talked about sort of comparable licenses, which are the bottom-up approach. You can take a top-down approach, looking at the overall sort of aggregate royalty burden on a standard applied to a product. But I don't think any particular economic sort of metric or analysis is excluded. So everything is. There's no textbook that you can look at for these kind of disputes. It's a commercial negotiation that you've got to have. Otherwise, the court will impose their own hypothetical negotiated outcome on the parties.
So there's another question, I think, that the panel or all of you could probably chip in. Can questions over validity of patents claimed to be SEPs be determined in mediation and arbitration? If not, what are the legal, policy, and administrative limitations that prevent such adjudication in alternate dispute resolution forums?
Sorry.
John, would you want to take this question? Because, I'm kind of pretty, as I said, when we do talk of validity, it's an issue that has to be settled by the court. And because it is a right in rem. So maybe you should take this question.
Yeah, look, we can't decide on the parties can't decide on the validity of the patent generally, because it's a registered right. It's a right that's registered in a patent office, and it's a right that applies as against the world. And so that's why if determining the validity is important, and the implementer really does want the answer because they're not persuaded it is a valid patent, or essential, there would have to be a trial on that. Just as an aside, sometimes parties do argue about validity as well as infringement at mediations. I'm not necessarily talking about FRAND mediations here. And so I have mediated on the odd occasion with a non-binding expert report about validity. But that's as close as you get, I think. So it was like having a co-mediator, a silent co-mediator on my shoulder. Every so often, parties refer to this non-binding expert report on validity of this, whatever it was, this IP right. And actually, what was quite useful, but the parties could construct a license, and that in effect would mean they've accepted the validity of the patent, although they might construct a license that terminates if the validity is declared invalid at any particular point in time. But we can't do anything in a mediation in a private forum about a registered right. Nor can an arbitrator, by the way, I don't think.
Dr. Heike, your comments?
Thank you very much. No, I mean, I echo what John and Archana just said. Perhaps just to mention that, of course, in an arbitration, and we have seen this in some patent-related arbitrations, not necessarily in standard essential patents, but more generally patent arbitration. There, the validity of a patent has been raised sometimes by the defendant, and in principle, the arbitral tribunal could decide on that claim. However, the outcome would remain between the parties, so it would only be relevant in the context of the arbitration and the arbitral award itself, but it would not have that effect that John and Archana mentioned, that the office where the right has been granted and registered would be affected. So it would be only, as we say, inter partes effect. Whether that's possible or not, again, may depend on the applicable law. So it's a bit complex legal question, but it is in principle within an arbitration possible between the parties, but quite unusual, I have to say. I don't think it's a typical relief that anyone seeks in an arbitration, because if really a party wants to challenge the patent, then it would go to the IP office or the IP offices where it has been granted.
I think there is one interesting question which is common for all the panelists, and it has come from multiple participants. What is the difference between FRAND disputes?
Can you repeat that? What is the difference between FRAND disputes and IP disputes?
Other IP disputes.
Okay, I'll go first, maybe, and then be short. FRAND disputes, as I already said, FRAND SEP holders have given an undertaking to the SSOs of where they have contributed their technology and patents, that they'll offer a license to the implementers on a FRAND basis. So in that sense, as an SEP holder, by way of that undertaking, I have in a way given up my right to pursue an enforcement action as the first remedy. So my first approach as an SEP holder would always be to offer a license to someone who is using that technology. So in that sense, my hands are tied. I have to offer a license, wait for the other side to either act as an unwilling licensee or not agree to a license to approach either a mediation or arbitration panel or a court of law to decide the issue at hand. So this is the major difference that I see in terms of enforcement of my rights.
Ms. Shanker?
I think I just agree with Nishant. That's pretty much, litigation is not the first option for an SEP holder. It has to be through negotiation.
Mr. Lang?
Yeah, I mean, in an IP dispute, the IPR owner can apply for injunctions and all sorts of things. Doesn't necessarily have to offer a license. Some organizations hold hugely valuable IP, but they're not in the business of licensing. They don't want to license anyone. They don't want anyone to use their patents. And there's no reason why they should give anyone the right to use their patents. But in FRAND dispute, you don't have a choice if you want your patent to be regarded as part of the essential standard. You've got to offer a license on FRAND terms. The difficulty is working out what FRAND is.
Dr. Wollgast?
Thank you. Yeah, perhaps just additional thought concerning now, if I look at it through the mediation, from the mediation angle, you know, what is the difference between an SEP mediation and another IP or patent related mediation? I think what we see is that there are very specific expectations by the parties, you know, concerning the qualifications of the mediator or also the arbitrator. So there's really a high level of expertise that's required. And I think really that also makes the difference in the case once it goes forward. And I think the other element probably is that many, if not most of the cases, at least that we see, are really international or even global. You know, it's really this very international scale. It's rarely limited to one jurisdiction, and that of course adds, you know, a whole range of issues that need to be considered. And then I think the third angle is probably confidentiality, and you know the really how aware and careful parties are concerning the use of confidential information as compared to, I mean, confidentiality is very often an issue in IP disputes, especially in patent related or trade secrets related, but we note that in SEP related disputes there's an even higher level of concern.
Yeah, probably an added burden in an SEP dispute is establishing the essentiality. So other things remaining constant, remaining same, essentiality is another added burden in SEP litigation or dispute.
I think we have a lot of other questions, but given to the paucity of time, we could, I think, take them over emails, if that's okay. So thank you all the attendees for your engaging questions, and to esteemed speakers for the comprehensive and thoughtful responses. We hope you leave with valuable takeaways and renewed perspective on the importance of fair, efficient, and innovative dispute resolution. With that, we formally conclude yet another insightful and engaging WIPO-FICCI-ICA webinar. Thank you once again, and we look forward to continued collaboration in advancing and strengthening the IP dispute resolution framework. Thank you so much.
Thank you.
Thank you so much.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.
Thank you.